Hello again. It's me, your favorite intellectual property legal English teacher, back again for part 3. How to obtain a patent. I will note just from the outset that I'm going to talk mostly about how it works in the United States, and each country will have its own system and process to obtain a patent. They're mostly the same, or very similar anyway, but always be aware of those distinct differences in your jurisdiction. Again, my name is Jeff Keiser. I am a practicing attorney from the United States. I have worked on big cases and small cases, but most of all, I love being a legal English teacher. And I hope that these classes help you get a better grasp on English, on how we use it in conversation, and how we can use it in our practice of the law. So I have condensed what would be a very long book about how to obtain a patent into 8 steps. And the United States and most countries have made this a relatively easy process if you know what you're doing. The layperson may get lost in a lot of the very technical aspects of filing for a patent. But if you do it one time, you know how it works and everything works better. So it's 8 steps. And the first thing to do is we need to determine if patent protection is appropriate. Like we said in the last class, the Coca-Cola formula is not patented. And they have chosen as a company that it is not appropriate for a patent. Now, once you get past that, let's say that they did want to patent Coca-Cola, they would have to determine if it was a patentable form of intellectual property. I would argue that it most certainly would be. It's a formula that was created by Mr. Coca-Cola, whoever opened the company back in 18 something, and he's the author and created it. It should be protected. Once you determine that, you need to conduct a patent search. And this is the phase where a really great lawyer is often very much needed. This requires going into various databases. In the United States, there's an online database, and you can search patents, every patent in history if you feel like it. And your goal is to determine whether or not your patent has been invented before. There's the famous story of Edison versus Tesla. Who invented the radio? We really don't know. And they both might have invented this at the same time. But once you get past that patent search, you determine what kind of patent you're looking for. What do you need? Is it a design patent? Is it a utility patent? Is it a plant patent? Is it a software patent? That one should be relatively simple. Now, these next 2 steps we probably could have combined into one. We prepare to submit our application, and then we submit our application. There are vast forms that are required to fill out and submit. It's like any other legal form. They're never a lot of fun to work with, but they're part of the job, right? Once we submit our application, we'll be in contact with the patent office, and the person we'll speak with is the patent examiner. They'll ask us questions about whether it fits in this category or that category, and they'll also look at old patents to see if there is any problems with it. Once you're approved, you pay your final fees, and then you get the magical rubber stamp patent. And then it's yours, I won't say forever, but at least for a long time. So, are you ready to file? Like I've said, you cannot patent an idea. only an invention. So while you don't need to have a functional prototype, you do need to have a very detailed description of that invention. That can be in the form of sketches, of drawings, CAD files. The more complex, the better, but it's often really difficult to be too complex. The description needs to be detailed so that someone with average skill in the field could look at the description and understand your invention. So maybe you need a 3D rendering. Maybe not. Maybe it's a very simple invention. But you need to describe it fully and with great, great detail. Like I said, this patent search is an incredibly important phase because it defines the process of innovation. You have to look at what other patents exist in the field before you say that you deserve a patent. There is a lot of overlap here, and I would recommend talking to an expert in the field, a real patent lawyer, to make sure that you're not inventing somebody else's idea, or vice versa. This is complex and takes a lot longer than we think, but it's an important thing to work on. Originality. This is a basic requirement for any form of intellectual property protection. We have to show that the work was independently created and possesses even a minimal degree of creativity. That's what makes something original. And that's, in all of this intellectual property discussion, that's what we really need to show, that it's our idea, not someone else's. So, here are the 8 steps to patent protection. Once again, it's definitely not it's not the most fun subject in the world, I admit. But when you break it down into parts like that, it's not that bad either. So next time, we're going to talk about what happens when someone infringes upon our patent. This is where we can start suing and where we can get the big bucks. So stay tuned. We'll be back soon.